Good afternoon and good morning to those not on the East Coast. Thank you so much for joining us today. I'm Trent Taylor, and I will be your MC for today's presentation. And we have a great panel of presenters and a jam-packed presentation for our special Halloween edition of our food and labeling webinar. As you know, we try to do these once every few months just to get our clients and our friends and others who are interested caught up on some of the latest regulatory and product and food labeling trends and goings-on out there. So here's what we're going to do today, just to give you a little bit of a roadmap. I'm going to start talking about some high-level trends that I have seen in the last few months. And then I'm going to turn it over to Royce Dubonnet, who will be speaking on recent regulatory developments. Royce will then tag Jenny Price, who will be talking about product labeling. Jenny will turn it over to Ben Abel, who will be talking about food and beverage labeling trends. And then Ben will hand it over to Bethany Lucas, who will be talking about Prop 65 trends that she's seeing. And for those who don't know, we're from a variety of different offices. Jenny and I are in the Richmond, Virginia office of McGuireWoods. Royce is in Chicago, Ben is in Charlottesville, and Bethany is in Los Angeles. As always, our questions that you may have are welcome. If you think of them during the presentation, you should feel free to, there's a Q&A button on the platform that you can submit a question, and we'll be happy to try to answer it either during the presentation or afterwards. Or if you think of a question down the road, tonight while you're lying awake in bed, or, next week, feel free to contact us, and we'll be happy to provide you our perspective on it. A couple of quick advertising notes. As always, I'd like to mention the fact that we have a labeling hotline. If you have an emergency that you need instantaneous reaction to, feel free to contact us at that email and that phone number. We also have a monthly newsletter that goes in depth on labeling trends that you can subscribe to. So if you have any interest in that, let us know, and we'll be happy to talk about that option. And then one other thing I wanted to mention real quick is that we do customized webinars and training sessions for our clients and friends as well. And we can customize it to your particular products. So, for instance, we did one recently for a coffee company, and they wanted us to do some training and talk about some of the trends related to coffee products, and we were able to do that. We can also do a presentation on defensive writing and careful communications to your business people to reduce risk. So if you have any interest in those, please let us know. All right, I'm going to start by jumping in with some current scary trends that I'm seeing out there. And the first one, and perhaps the scariest of all, is that there are more class actions in this space than ever. And I'm not sure why the pandemic has goosed the number of class actions filed, but it has. I get an alert every time a new labeling class action is filed anywhere in the United States, and that you would be shocked at the number of alerts I get every day on those. There are a lot. Now, that's in part because of one particular plaintiff's lawyer who has filed a lot in New York federal courts as of late. And Ben's going to tell you a little bit more about that in his part of the presentation, but that doesn't explain it all. There are a lot of class actions going on, being filed right now. And what does that mean? Well, I think it means that we should all be preparing now because the zombies are coming. There are lots of plaintiffs' lawyers looking for new revenue streams and testing out new theories. And I talk to these plaintiffs' lawyers all the time, and they tell me they're busier than they have ever been. So now is really the time to review your labels and attempt to mitigate the risk of being sued if you can. Okay, trend number 2, toxic chemicals. we are continuing to see an uptick in the number of suits targeting foods for minute levels of allegedly toxic chemicals. Here are a few examples. You may recall that we've talked in the past about glyphosate cases, and we continue to see those, but it's now being expanded out to other chemicals. So here are several examples of a nonprofit, and I'll use nonprofit in air quotes there, suing some coffee manufacturers in D.C. Superior Court for those products containing methylene chloride. And they're using the label claim of pure as the hook. And we're seeing a lot of these types of suits, not just from nonprofits, but also, sort of your typical class action from consumers as well. Here is actually an example of one of those types of suits, the first generation of these types of suits that recently got dismissed on summary judgment related to glyphosate. But that case did in fact get to the summary judgment stage before it ultimately got dismissed in just the past couple of months. And if I recall, that class had actually been certified as well. So a good result in the end, but it took a while to get there. So these cases do potentially have some lags. And here are some other examples. You'll see highlighted in red, insecticide, a couple of glyphosate cases, but also arsenic and heavy metals. So something to pay attention to and to be aware of is this particular trend. And really, in some ways, this is the most interesting part of this particular trend is a lawsuit for essentially disposable plates. And the label claim in this particular lawsuit was compostable. And the allegation is that claim is deceptive because it actually contains PFAs in there. And so I think this is really the future. And we're going to see a lot more focus on these environmentally friendly claims going forward. So if you have any environmentally friendly claims, whether it's on a product or a food product, related to the container, then you're going to want to pay very close attention to those. Another trend, and I don't want to steal Ben's thunder because he's going to talk about this in more detail, but I would be remiss if I didn't mention it as a high-level trend. Flavorings litigation has exploded, and it's not just vanilla. So I'm just teasing it for you. Ben will talk about that more here in a few moments. Another trend is sugar. Sugar is still a big driver of label litigation, and here are a few examples. As of late, there has been a targeting of label claims like low sugar, reduced sugar, sort of sweet, just a tad sweet, lightly sweetened, slightly sweet, a bunch of euphemisms where the amount of sugar is being quantified on the front label, and you got to be very careful with that. And those have been targeted by several class actions in just the last few months, in part because the CSPI earlier this year had a petition about low sugar and reduced sugar claims. One other thing I'll mention real quick that I don't have a slide for, but artificial preservatives, and that's a first-gen food labeling claim as well that's bounced around for a number of years, but it still has legs. And in some of the cases that have gotten the furthest, class certification and big settlements are those involving artificial preservatives, and those have a higher likelihood of the plaintiffs beating a motion to dismiss more than a lot of other cases, and those involve a variety of different ingredients like malic acid and those kinds of things. So that's something else to keep in mind. And then my final trend, real quick, I wanted to flag a couple of cases on the appellate front. So some of you may be aware of this top case here, which is the Johnson case, which a panel of the 11th Circuit decided last month. And it reversed approval of a class settlement saying that the incentive fees that were paid to the class reps were illegal. And it's a startling decision in a number of ways, but in part because Judge Newsom, who wrote the opinion, talked about how it's very clear that these incentive fees are illegal, but he relied on cases from the 1800s to do that. So it's caused a lot of waves. I think it could complicate class action settlements going forward. And really, the thing I think to really pay attention to is I see this as a start of a new type of attempt by some newer judges on the bench in appellate courts to start dismantling the class action settlement mechanism. So that's what I really want to focus on. There's a couple of other things on here that I also think are interesting, but in the interest of time, I'm not going to talk about them right now, and I will now pass the baton over to Royce to talk about regulatory.
Yeah, thanks, Trent. And my regulatory talk here is going to focus a lot on, what's happening with cannabis, CBD/hemp, and then some unique trends that I've seen FDA pull out of their hat towards the end. This right here is FDA's on the phone with FDA the other day. They said they weren't progressing on CBD because their current office was haunted. Joke. It's not really haunted. I think they're working really hard there. On this, where are we right now with CBD, and where is FDA with CBD right now? And we're just going to take a quick time machine back to March, where FDA submitted to Congress a series. It was a hearing in. They had a packet, and if you email me, I can give you what FDA submitted. And FDA basically said, look, we're not really there yet with CBD. We're still trying to figure out how we're going to enforce. Fair enough. But there's also saying in here that, some key takeaways are we could see CBD as being regulated as a dietary supplement. We're considering that approach, not off the table. So from that, I think that's interesting that FDA was considering that, and it's not just a black or white. It's either a drug or not a drug. But there's also been some other hints that we saw in that where FDA was saying, we know that there's liver toxicity here. We know that there's some other things that could go wrong with CBD in a very diverse human population, from elderly to children, across the spectrum, and we need more time to figure that out. But we also recognize that, and this is FDA, we also recognize there's a significant market interest and a huge market in CBD. Fast forward a little bit to July. We do know what FDA did last summer. FDA's report to Congress on July 8th shows that not all CBD has been labeled properly in the marketplace, and my colleagues will talk a little bit about labeling claims and labeling later on, but FDA did a whole poll. They basically went around, pulled CBD off store shelves, and compared it to say, if it says that it has 10 milligrams of CBD content in the packaging, and does it really have 10 milligrams of CBD content? And the numbers were pretty harsh. FDA said only 35% of products tested contain consistent labeling claims out there. FDA did not test for impurities, and we have seen FDA go after impurities to some extent as part of a current good manufacturing practice warning letter, things like that. But the bigger issue, I think, out there is that FDA has basically told Congress, not everything out there is labeled properly. It could be a departure in the fact that we have no confirmed scientific USP level grade, testing for CBD in products, or it could be that there's just a bunch of actors out there that are not as sophisticated as they need to be making human consumable products. Where do we see FDA going? And we know that from a filing on July 22nd that, and this is the Office of Management Budget, basically every admin agency before they file regulation has to impact, basically an economic impact on the regulation. That's a huge paraphrase of the detail that goes into it. But we know that there's a draft enforcement policy out there. And my colleagues at MWC, at McGuireWoods Consulting, tell me that it is currently under review at the executive branch. Industry is meeting to discuss what that enforcement policy looks like. But that draft enforcement policy will come out. It's in draft form. FDA has it. It's typed up. We just don't know when it's going to be let go. And that could be very dependent on what happens this November. And whether or not there is going to be an administration change or not, because it could really affect the way, either the current administration or new administration, if that happens, would want to take on a draft policy that might not be exactly what they want to do. So we know it's out there. We just don't know when it's going to be let loose, and I continue to monitor that. DEA came out with something really interesting. This is the way I view DEA, as a kind of in a slasher film like The Shining, but it's essentially what DEA wants to do, or we think DEA is going to do to the Farm Bill. DEA came out on August 20th with a very interesting announcement or interpretation of the 2018 Farm Bill. We know that, in its basic hemp knowledge, that anything that is above 0.3% delta-9 THC on a dry net basis, it could basically be considered marijuana under the Controlled Substances Act. And farmers, growers, processors, manufacturers, food and beverage companies, everyone's goal is to keep it below that 0.3% THC. But DEA came out with a very harsh interpretation of that and said that it essentially, at any time during the manufacturing process or during the entire history of from when hemp grows in the plant, or basically when CBD is in the plant, to when CBD finds itself into a final end user product, if the content goes above 0.3% delta-9 THC, DEA would consider that marijuana. That's a really harsh and rigid interpretation of the Farm Bill, and I think the ideas behind the Farm Bill. And it essentially is still in draft form. This is not law yet. But it essentially means DEA might be taking the position that at every single step of the process, you need to be monitoring the content of THC in your product. There is an open comment period. Comments are due October 20th. And we're not sure if DEA is really taking this harsh process. Maybe they didn't read the Farm Bill exactly. Maybe they don't understand the impact that such a harsh interpretation might have. But we'll continue to monitor that and see what DEA does and see if they begin to understand things from a little bit more practical standpoint. The other thing that we always need to keep in mind when looking at any issue involving CBD or cannabis is the National Advertising Division, the NAD. And NAD is, it's not a governmental agency. It's the Better Business Bureau Administration, but NAD has been very active in this space. And on September 24th, we saw there was a referral from Ask LLC to FTC, and that's really the NAD's main tool. Is if NAD comes out, if you were brought in front of NAD or you bring someone in front of NAD for basically a arbitration-style hearing, it's basically a, there wasn't support behind your claims and we're going to bring you in front of NAD to figure out a way to resolve this issue outside of court to get you to where we can have the claims change or have substantiation. It's not really seen as, it is, but it's not seen by NAD to be a true adversarial process. But if you don't listen to NAD, and NAD has told you that your claims need to change, NAD can do a referral to the Federal Trade Commission, which could take up the issue and decide to file civil penalties or refer elsewhere. And we've seen NAD be more active in this space. And it really, the key here is that when looking at NAD, it's not just the Food, Drug, and Cosmetics Act. It's really substantiation of claims. It's a different standard. So if you have a CBD product or a cannabis product out there and it's making some claims, yes, you should always be mindful of what the current FDA enforcement trend is out there, but you also have to be mindful of what is the substantiation behind each claim that I'm making, and can I really defend that? Do I have the studies? Do I have the evidence that shows that this is the case? Because if my competitor wants to, it doesn't have to be a competitor in the cannabis space, wants to bring me in front of NAD, can I substantiate that? So just a tip out there to think about NAD, and we'll continue to monitor what's going on at NAD. one of the final takeaways that I want to give is what I call my pet cemetery roundup. These are just things that I've seen out there that FDA is focusing on, and as just a basic understanding, FDA is completely, entirely consumed by COVID-19. We have seen reduced guidance production from FDA. We've seen slightly reduced enforcement in non-COVID-19 areas. So the agency really is taxed right now. And that kind of has allowed some people to say that there's a lot more enforcement discretion out there, but I wouldn't take this as a norm. This is a temporary period in time, and hopefully COVID-19 ends. But one of the interesting things FDA published out there was the seafood list. They had a compliance policy guide basically published on the seafood list. And if you don't remember, the seafood list is this official list out there on what the common name for fish or seafood products are, and then what the market name is, and then what FDA will say is permissible. And there is a compliance policy guide out there now which directs the field offices to it's essentially a guide for the field office to decide what to do on import or on sale. And it's just a reminder that FDA, even during COVID-19, has taken a renewed interest in making sure that seafood products are labeled correctly, accurately, and in accordance with the seafood list. If you'd like a copy of the list or you'd like a link to it, please just email me. I'm happy to forward that on. The other two final remarks that I'd like to say are the California Prop 12 is still very real and out there. California Prop 12 is the law out there that talks about correct caging or housing of farm animals. I got an email from the individual working on it at the California Department of Food and Agriculture. They said comments aren't open, but we have a draft version out there. This is still very much going to happen. We're targeting 2022 for pigs, and it affects every single piece of, what I'd call raw pork meat that isn't part of kind of a final meal that comes into California, and California is going to be checking to make sure that you are registered with the state and that the housing for the animal is humane. And then the last trend I saw is there's been a lot more emphasis by FDA based on warning letters on prevention controls. This includes accidents on the line where potato chips can fall into the wrong potato chip container, or it can be, co-mixing two different kinds of salad dressings accidentally. Mistakes can end up resulting in warning letters, so just a good back check, make sure that everything is going on the line and going where it needs to be. And I'm going to hand off to my colleague, Jenny.
Thanks, Royce. I'm going to be talking to you guys about the product labeling. And to jumpstart off of where Trent identified his trend number one, that's going to be the focus of the labeling and COVID-19 slide. So there was a Law 360 article, COVID-19 Accelerating Growth of Class Action Lawsuits. And that article was based on a Carlton Fields class action survey that was done towards the end of May of 2020. And at that point, there had been a sharp increase in new class action filings. Specifically, there had been 560 COVID-19 related class actions that had been filed by the end of May. About 25% of those were against insurance companies regarding business interruption coverage. Another 25% of those COVID-19 class actions related to concern about education refunds. But there is also a lot of COVID-19 class actions that have been filed regarding marketing and advertising claims, specifically related to products that consumers are buying in bulk related to COVID-19. So the first one I'm going to talk about is Clorox. Clorox had a nationwide class action that was filed in the Northern District of California regarding its splashless bleach. And the allegation is that splashless bleach does not have the same disinfectant power as regular bleach, in that the label is insufficient. The label is on the back, of the Clorox bottle, and it says on the back in what is alleged to be small print that the splashless product is, quote, not for sanitation or disinfection, but to sanitize and disinfect, you need to use Clorox regular bleach. So there is a allegation against Clorox that that is an insufficient and misleading label on its splashless bleach label. The next company that has seen a class action filed also in California, it's a nationwide class action with a California subclass in the Southern District of California, is wet wipes. And the allegation in this lawsuit, again, relates to the labeling, where the hand wipes are labeled as being able to kill 99.99% of germs. And the allegation is that the active ingredient, BAC, is actually ineffective against certain viruses like norovirus and certain bacteria like C. difficile. And so it's actually not killing 99.99% of germs, unlike what its label says. And then Molecule, which for those of you that don't have their Instagram inundated by Molecule, like apparently my Instagram account is an air purifier. And this is a picture of it up here. It's sort of like a silver air purifier with a leather handle on top. And they actually are facing a class action that is alleging that the air purifier does not destroy germs or eliminate indoor air pollution as it advertises. This was filed on the Eastern District of New York. And this lawsuit came on the heels of something that Royce had mentioned with NAD. Dyson had brought an NAD action against Molecule. And after that NAD action, Molecule had corrected some of its marketing slogans and campaigns. And then after that NAD action is when this class action was filed. Hand sanitizers, similar to the labeling increase in class actions with Clorox and wet wipes, you're also seeing a lot more class actions involving hand sanitizers. This is probably I think the third time we've talked about hand sanitizers with this webinar specifically. And the two new hand sanitizer class actions both have to do with alcohol-free hand sanitizers, where the allegation against both Germ Block and REI are that the hand sanitizers are advertised as killing 99.99% of germs, but the allegation is that without the alcohol active ingredient in those hand sanitizers, that they're not that effective in killing germs, and that their labeling is misleading and deceptive. The other interesting thing that I found when preparing for today's webinar is that I just Googled hand sanitizer lawsuits. And the first thing that pops up when you search that on Google is a new website that I had not seen before. And it's by Kazan, McLean, Satterley, and Greenwood. And it's actually it's a firm. When you click on it, the website title is www.handsanitizerattorneys.com, and then it takes you to the Kazan McLean website that advertised that they've recovered $4 billion in verdicts and settlements, not specifically related to hand sanitizers per se, but they are clearly holding themselves out there as hand sanitizer lawyers on the plaintiff's side. But I thought that was a very interesting development, and just really highlights that class actions are definitely booming, as Trent pointed out, and I think that there are a lot of plaintiff's attorneys out there that are targeting products that are specific to the fight against COVID-19, whether it's Clorox, wet wipes, hand sanitizers, air purification systems. So if there are products out there that your companies are selling, that definitely should be on your radar to make sure that you're reviewing the labeling and the marketing, advertising, websites, to make sure that the claims that you're making about your products are true, accurate, and can be substantiated. The next trend that we've seen in labeling class actions is with infant pain reliever class actions. There are at least 8 retailers that have been hit with class actions. The allegation is that the packaging of infants and children's Tylenol, or acetaminophen, I should say, is misleading to caregivers, thinking that the 2 products are different or have a different amount of the active ingredient acetaminophen, because one is being labeled as infants and one is being labeled as children's, when in fact they have the same amount of acetaminophen, but the infant formula is about 3 times as expensive. This has been, suits have been filed, 2 in California, 1 in Florida, 1 in New York, but there are about 8 different retailers that have had to respond to class actions in this area. The next trend that we've seen is with mineral-based sunscreen. Bayer has they're facing a nationwide class action in the Northern District of California about allegedly deceptive marketing related to their Coppertone mineral-based sunscreen. The allegation is that when Coppertone holds itself out as being mineral-based, that the implication is that the main active ingredient is a mineral ingredient like zinc, opposed to a chemical active ingredient, when in fact the allegation is that the chemical ingredient is actually the main ingredient, the main active ingredient. And that lawsuit they responded and tried to make a primary jurisdiction argument that FDA should really be the one that handles this lawsuit, which was rejected by Judge Cousins in the Northern District of California, and so that lawsuit is moving forward against Bayer. But both with the mineral-based sunscreen and the acetaminophen lawsuits, again, the importance of just making sure that your labeling, marketing, claims, advertising is accurate and can be substantiated, which is also the theme of the new lawsuit that was filed just a couple days ago against Igloo. The Igloo cooler advertised that it could hold ice for 5 days. It would keep ice cold for 5 days. The plaintiffs in that case are alleging unfair trade practices and fraud, saying that their cooler actually only kept ice for 2 days, and they had to replenish the ice several times during that time. And so, saying that Igloo saying that it was able to have ice in it for 5 days is false, misleading, and fraudulent. And so that was just filed in the Eastern District of California just a couple days ago. But again, just highlighting the need for your marketing and labeling websites to have accurate information that can be substantiated if a lawsuit is brought against your company. And I am going to pass it off, I think, to Ben Abel.
Hey everyone, this is Ben Abel. I'm an associate in our Charlottesville office, and I'm going to talk a little bit about some trends that we've seen in the food labeling world in the past few months. And speaking of Igloo, to kick us off, that suit is filed by the same attorney that has filed the flavoring lawsuits that Trent talked about at the beginning of the hour. And frankly, it would be foolish for us to begin anything about food labeling this year with any other topic than the flavoring suits. It has been the year of the flavoring lawsuit. These have been brought almost exclusively by, as Trent said, one attorney, Spencer Sheehan and Sheehan and Associates in New York. He's out on Long Island. They're almost exclusively filed in the southern and eastern districts of New York, though I've seen his name pop up on a couple of pleadings in California, so buckle in there. But those suits largely started as vanilla lawsuits, and we've talked about those on webinars in the past. But they've expanded from there, and they are so prolific that for most of the food lawyers on the call, we're not to the end of the year yet, but we'll be shocked that we will probably see more filings, and dramatically so, more filings related to food labeling cases in New York than we will in California this year. That is how many of these suits are out there. And the basic allegation is that there is some type of flavoring claim that's made on the front of pack for a product, vanilla ice cream, vanilla soy milk, vanilla almond milk. Those were the first kind of round of these cases. But despite that, the product is actually flavored with natural flavors or something other than pure vanilla bean or vanilla extract. And the allegation is the reasonable consumer, when they see vanilla almond milk, for instance, even if there's no affirmative claim of made with real vanilla, even if there's no vanilla bean or vanilla orchid on the label, the reasonable consumer interprets that to mean that the product is only flavored with vanilla bean and vanilla extract. That claim has been expanded, and as you can see here, there's been a lot more. But for instance, the Watson case, the same kind of claim, but it's about smoked Gouda. So your cheese is not smoked or flavored with the natural smoking process. It's flavored with some kind of natural flavorant, and reasonable consumer expects the cheese to only be flavored with the smoking process. The Hostess case, same with carrot cake. Basically, any type of flavor that you might have on the front of the pack, this type of claim could be out there. All of these cases, shockingly so, have nearly identical allegations. They all bring claims under New York's general business law, as well as for negligent misrepresentation, breaches of express and implied warranties, violations of the Magnuson-Moss Warranty Act, fraud, unjust enrichment, and then for injunctive relief. They are cut and paste complaints that are almost identical from one to the other. At the beginning of this process, they were on behalf of nationwide classes. They've kind of been beaten back into just being New York classes at this point, but really these cases are being litigated on the GBL claims. The other common law and Magnuson-Moss claims almost exclusively are dismissed by the courts for various deficiencies that for some reason plaintiff's counsel has not fixed from complaint to complaint over the course of the year. The injunctive relief, we had one judge, Judge Gardeffi, who said, maybe injunctive relief may be available in cases like this. We believe that the Bernie v. Barilla Second Circuit opinion regarding that class action settlement forecloses that in the Second Circuit, that the Second Circuit made it pretty clear that a past purchaser is not available or cannot get injunctive relief because they know of the deception. We've not seen a judge affirmatively use Bernie to shut that down outside of a report and recommendation from a magistrate judge, but we think that's pretty clear. And really, as these two opinions, the Sharp case and the Steele case, make clear, the divide really seems to be whether you've got a flavoring case or an ingredient case. And Sheehan is trying to make all of these cases into an ingredients case because Manteca's, the whole grain Cheez-Its case, and now the A&W case, where there was an affirmative statement of made with. So in Manteca's, made with whole grain, and it turned out that actually there was more white flour than whole grain flour. Or the A&W case, made with aged vanilla, despite the fact that the allegation is there is no aged vanilla. Those cases are surviving a motion to dismiss, as opposed to the Steele case where that was just vanilla ice cream with no made-with claim, nothing identical. The judge in that case said that's just a flavoring claim, and there's no allegation that these products don't taste like vanilla. And so if you get one of these cases, the first thing you should do, obviously, is pick up the phone and call McGuireWoods, because we would love to help you out. But the debate is really going to turn into whether or not you can cast your case as a flavoring case in which you have a pretty good chance of being dismissed, or an ingredient case in which will be a little bit of a tougher putt, but there are still ingredient cases brought by Sheehan that are being dismissed. So, but again, we've seen a lot of these. We've got a lot of letters and motions and the research done, and we'd be happy to help out if you see them. The next I want to talk about is some continued refinement of country of origin and region of origin claims. These continue to be relatively consistent. If you remember in the past, we've talked about region of origin claims. In the big takeaway was if you make an affirmative reference to your location on the label, so in Kona beer, for instance, come visit us on the Big Island, and it turns out that you're not brewing the beer sold in the continental United States in Hawaii, that could be deceptive to the reasonable consumer, that you basically are making an affirmative statement as to where it's brewed at that point. There was another case, 21st Amendment Brewing, same thing, come visit us at our brewery in San Francisco, except some of the beer was brewed in Minnesota. That survived dismissal as well. The Peacock case that we got just this month adds another wrinkle to that. That's over Olympia Brewing, or Olympia Beer, excuse me. It's owned by Pabst Brewing, and the allegation was a number of labeling claims and images, including waterfalls and scenic pastoral fields and all that stuff, made the consumer think the beer was brewed in the Olympia region of Washington State. But what the court focused on in denying the motion to dismiss was a statement that said, it's the water. And the court basically said, listen, a statement of it's the water is an ingredient claim that a reasonable consumer could believe that water comes from the Olympia area, and as a result, a reasonable consumer could be deceived if the beer is not really brewed there. So for a region of origin claim, if you are making a claim that come visit our bakery on Long Island, or come visit our brewery in Austin, Texas, and you're not brewing the beer there, that could be a problem. At the same time, if you are making an affirmative ingredient claim for an ingredient that is found in a specific place, and that specific ingredient, and your product's not being made in that specific place, Olympia tells us that could be an issue as well. So again, a good opportunity to go look at your labels, and if you're making some kind of specific geographic claim, think about that. However, we've seen a number of dismissals as well. In the Cento case, that was a case about certification, and the plaintiff basically alleged that Cento wasn't having its tomatoes certified by the appropriate consortium that certifies those sorts of things for San Marzano tomatoes. The court said it's not written in the stars that there is only one group that can certify where the tomatoes come from. There wasn't any serious allegation from plaintiff that the tomatoes weren't from the San Marzano region, and the court said that's the only thing that the consumers really care about. They don't care what consortium approves or disapproves of the tomatoes. They just care where it came out of the ground. And then a reminder, the Thornton Tyson Foods case, if you are a beef or pork producer, as a result of a dispute at the World Trade Organization, there is no country of origin labeling requirements for you. This was a case that said that beef that was sold as being processed in the product of the United States, when the cattle was raised abroad and slaughtered and processed in the United States, the court said, listen, there is no cool regulation for beef and pork at the time, and oh, by the way, USDA's FSIS guide says that would be appropriate for cattle that is slaughtered in the United States but not raised here. So just a good a reminder. These suits continue to be filed, including the R.C. Bigelow suit over Made in the USA claims as to tea. It's a patchwork of regulation as to Made in the USA. FDA basically defers to FTC. California has its own regulation that I believe is now no more than 10% of the product can come from outside the United States. So if you want to make a Made in the USA claim, talk to us, because it is not one easy regulation to pull in the rule book and say we comply or don't comply. And finally, before I pass it on, we've seen in the last couple months a boatload of suits specifically about coffee, and the specific allegation being that your package says that this container makes X number of cups of coffee, but when I go and actually do that and I follow your instructions on how to make the cups, it doesn't make that. So your container says makes 200 cups of coffee. When I follow the instructions as printed on the package, I only get 150 cups of coffee, and you're shorting me. It's something like a slack fill suit. Obviously, there's a slack fill regulation that would be not an issue here. But again, it's just, am I really getting the amount of product that you say I'm getting? We've only really seen these in mass when it came to coffee. So, of course, if you have a coffee SKU, go look long and hard at your label, and go look long and hard if you have any serving or number of servings on your label, because they certainly are headhunting in the coffee space. But more generally, if you've got any sort of makes X number of servings, not in the nutrition fact panel, but some affirmative statement on the front of pack on the principal display, it might be a good opportunity to look at that for two reasons. One, is that true? Do we make as much as we say that we make? And if that's incorrect, then that's something you're going to want to think about and think long and hard about your risk tolerance. But B, if we do think that that's right, are our instructions as clear on how to get to that number of cups of coffee, that number of slices of bread, whatever it is, that consumers aren't confused in following a wrong process? I suspect in some of these coffee cases, it's going to be an issue of the instructions they thought they were following weren't what the company intended. I don't know that for a fact, but for both of those reasons, I would, if I've had an affirmative claim like this on front of pack, I would make sure that that's actually correct. And then second, to the extent it's correct, that our instructions are as clear as possible. And that is clearly a pretty portable claim from just coffee to any number of other products. So like we've seen flavoring explode from vanilla to everything else, I wouldn't be surprised if we start seeing this with other products that make an affirmative number of servings claim on front of pack. With that, I will be done, and I will turn it over to Bethany for the wild world of Prop 65.
Thanks, Ben. I'm going to jump right in, and before I do so, I just wanted to mention, Jenny talked a little bit about some COVID-19 class actions, and just wanted to do a little bit of marketing and point out that on the class action blog post, class action countermeasures that we run here at McGuireWoods, there is a series of posts about class actions related to COVID-19 and all sorts of different industries, and some things to think about in terms of whether those class actions will ultimately be viable from a class certification standpoint. So like the plaintiff's lawyers on the class action space, the plaintiff lawyers in the Prop 65 space have also been very busy during the pandemic. And Exponent, who is a expert consulting group who does a lot of work in the Prop 65 space, noted that there was a 40% increase in the June-July period of 2020 in notice letters for Prop 65 compared with the same time period in 2019. and the hot areas, really over 50% of those new notices are in the food and beverage area, dealing with acrylamide, inorganic arsenic, cadmium, lead, and furan. On the sort of industrial and consumer product side, it's chemicals like the phthalates, the DEHP, DINP. Again, lead and cadmium seem to be really hot right now. Hexavalent chromium, BPA, carbon monoxide, and wood dust appear to be sort of hot areas amongst plaintiffs' counsel. The first case I want to talk a little bit about is the Roundup cases. We spoke about those the last time back in June, and although this decision came out right around the webinar, there has been an update. Just as a reminder, the court, Judge Shub in the Eastern District of California, permanently enjoined the state from enforcing Prop 65 warning requirements for glyphosate, and they basically said that order violated plaintiffs' First Amendment rights, and it was based on the fact that the state listed glyphosate without really sufficient scientific evidence that that chemical is cancer-causing. And so, as we expected, the California Attorney General has appealed the case, filed the notice of appeal on September 9th, 2020. They recently filed in the Ninth Circuit, you have to file a mediation statement if you are the appellant. And the court sort of indicated that it's possible that he thought that this case might be able to be mediated, which I find really interesting, given that it is such a really critical issue of law as to whether or not the state is able to rely on sort of minority scientific view to compel a manufacturer to put a labeling or a warning on a product. We're going to be watching that briefing schedule. Opening briefs are due mid-December. Answering briefs are due mid-January of 2021. Another series of cases out here that we've been following are the coffee cases dealing with acrylamide. These cases have been pending for really 10 years, originally filed in 2010. As we all know, there was a new reg, section 25704, that went into effect in October of 2019 that basically said that the chemicals created in coffee during the roasting or brewing process don't pose a significant risk of cancer. And we finally had dismissal of those coffee cases by a LA Superior Court judge, Judge Burrell, dismissed the cases, finding basically there wasn't sufficient evidence that the acrylamide that accrued during roasting or brewing caused cancer. And so that's a big win for the coffee industry. But there is a trend here with acrylamide cases. There is an ongoing case, California Chamber versus Becerra, which we talked a little bit about, I think, the last time, where the California Chamber is suing to enjoin the state of California from enforcing acrylamide cases and Prop 65 warnings. That case had a motion to dismiss back in August that was denied. The state had moved to dismiss the complaint. The complaint had been amended to, again, use this First Amendment argument that we saw in the coffee cases, in the Roundup cases. And so that issue is also pending, but the court said there wasn't enough to dismiss the case on a motion to dismiss and that it can proceed. But as you may have seen, there is a proposed regulation that is currently in the comment period dealing with exposures to listed chemicals in cooked or heat processed foods. So in the interim, based on significant lobbying, significant involvement with the state of California is trying to preserve some sort of labeling requirements, recognizing that the heat and baking process does create some levels of acrylamides, but attempting to keep manufacturers at sort of the lowest feasible levels is what they claim in the proposed rule. And the regulation basically lays out what constitutes exposure for purposes of Prop 65. In other words, if you get above these parts per billion levels that are listed in the regulation, you would have an obligation to warn. If you're below those levels, you would not. Again, the notice and comment period is open yet for another couple of days until October 21. There has not been a hearing on these proposed regs. There was initially requested one, and then that was denied in part because of the hearings are limited because of COVID. But I think it's interesting, since October of 2019, there have been over 500 notices that have been served against companies based on acrylamide and food. So it'll be interesting to see, how the lawsuit ends up. It's sort of tied to the Roundup lawsuit, the First Amendment issue, along with this proposed regulation. It'll be interesting to see the comments and commentary and whether there are changes to that regulation after the notice and comment period. And finally, I'm just going to end with an interesting article that I came across in the LA Times that was published on July 23rd, 2020 by Jeffrey Mohan. It says, "You see the warnings everywhere, but does Prop 65 really protect you?" And it's really a critical article of this whole requirement statute and regulations, looking at it from the perspective of, has it been watered down so much? Because as Californians, we see these labels everywhere, and they really don't tell you much. They don't even necessarily tell you whether the chemical is in the product or not, even if you see a warning label, because the gut reaction of most manufacturers, it's a little different in the food and beverage space, but still exists in the food and beverage space, is you're safer to have a warning on your product than not. And so if there's a potential of having a chemical in your product, a lot of people and a lot of manufacturers decide that it's from a risk-benefit standpoint, even if they don't have the chemical in their product, it's worth putting a warning on it just to protect themselves from the private litigants and the nuisance and legal expense of having Prop 65 warnings on it. So I think it's going to be interesting from a more sort of global perspective to see if we start to see changes in the law, more efforts by lobbying groups, food and beverage groups, the California Chamber, to push back on the requirement to have labels on sort of thinly supported scientific claims associated with cancer or reproductive harm. And with that, I'm going to turn it back over to Trent.
Thanks much, Bethany. We are at the end of our hour. One quick wrap-up thing that I'll note, and hopefully it comes through when we do these webinars. We love talking about this stuff. We live and breathe it really all day, every day. And we're involved in a lot of these cases. We're involved in some of the vanilla cases with Spencer Sheehan. As Ben mentioned, we're involved in the infant acetaminophen case, some of those cases. and we're involved in a lot of other labeling class actions, including slag fill. So if you ever have any interest in just chatting with us about it, you see an interesting trend or you have a question about something, always feel free to reach out. And obviously, if you get a demand letter or a new lawsuit in any of these areas, and we'd love to help you if you're interested. And we're like I said, we have a lot of experience and we're very competitive on pricing. So with that, thank you so much for attending. We really appreciate it, and we hope you will join us in future webinars that we do. Thanks a lot.